We're sitting down today because there's been a lot going on when it comes to your office, and I want to start off with the case, the attempted kidnapping case, that kind of brought a lot of attention over this past week. This is not the first case that our investigative team has covered where it's been dropped, a case has been dropped, or plans to be dropped because of a competency finding. We've covered other jurisdictions, but pretty much as soon as the news came out about this case, that it was likely going to be dismissed, it got not only local attention, but national attention. Why do you think that is specifically with this case?
You know, I can't speak to specifically why this case has gotten attention because, as you point out, there have been other cases where there have been instances if the defendant is incompetent and is unlikely to be restored during the course of the case, that those cases are required by state law to be dismissed. So I can't really comment on why this case has garnered specific attention.
Do you think that the criticism towards your office has been fair?
I don't think it's been fair. You know, we are following state law. We are required to follow state law. The statute provides under certain circumstances that charges must be dismissed. The court will make the ultimate determination as to whether or not charges will be dismissed.
So let's talk about that law. When, for you as a DA, did it start to come on your radar of the implications that the change in this law was going to have?
So the change in the law happened in 2024, and I think it was readily apparent that when the legislature changed the language from the court may dismiss to the court shall dismiss, that's concerning to me as a prosecutor because it doesn't provide for any exceptions. It doesn't provide for exceptions of a case of a homicide or a serious sex assault. There are no exceptions in the statute. And I think that we need to work with the legislature to find some sort of balance where we can be sure that we are working to make their community safe while at the same time getting mental health treatment for individuals who are seriously mentally ill.
In your statement, you said you've been talking to legislators about this statute. Can you tell me who you've been talking to?
I've been talking to members of the Arapahoe County delegation so far, and then I plan to talk to additional legislators as soon as I am able to.
What have those conversations been like?
They've been very positive conversations, very receptive, very understanding that this is a community concern, and we need to address this community concern as elected officials collaboratively, and so they've been very productive conversations.
What do you think a realistic solution looks like for this?
I think there's a couple points that need to be addressed. First of all, I'm concerned about the mandatory nature of the dismissal in all cases with no exceptions, and I think we need to look at some exceptions that can be carved out. I think we also have a serious funding problem for mental health treatment overall, and particularly in this type of situation. We hear stories of long waits for individuals to get their competency evaluations in the first place, and then to have restoration services, and then additional treatment. And so we do need more funding. I understand the state is under budget shortfalls right now, but this really needs to be a priority because it's an important community safety issue. And the final change I'd like to see is on the back end. So when someone is found incompetent and not restorable, what happens to that individual? So in this particular case, this individual had been released after charges had been dismissed by the Denver District Court. Here, this individual is subject to a short-term commitment order, a civil commitment order, so he will not be released, or she will not be released to the community immediately. But I think we need to work, if for example, they hadn't been released in the Denver case, this case might have never happened.
Yeah, a couple of follow-ups to that. Like you mentioned, the Denver case being dismissed. We've seen other cases where people are found incompetent and not restorable, and we literally watch them walk out of the courthouse, right?
Yes.
Because they're not being civilly committed and getting treatment. Why do you think there's such discretion over the people who are found incompetent and not restorable? What happens to them next? Some people are being civilly committed, some people are not. Why do you think there's a discrepancy there?
That's not my area of expertise, and I'm not entirely clear on that. I think a lot of that goes to medical judgment of the individuals that are treating them, but I think that's another area for legislative reform. I mean, if someone is so mentally ill that they can't understand the basic process of participating in their own defense, they can't understand the role of the judge or the prosecutor or their own attorney, they can't understand the charges against them, that person needs mental health treatment, and it's not right to just release them back onto the streets.
You mentioned too wanting to carve out exceptions depending on maybe the crime, right? What exceptions would you like to carve out?
I haven't had a chance to kind of specifically think those through, but I mean, when we're looking at crimes of violence, obviously homicides, things like sexual assaults, we need some more safeguards, additional safeguards in place to ensure community safety for sure.
I know you've only been in this office 6 months, and like you said, this law changed took effect last summer. When did it get on your radar of what was going on with this?
Yeah, I wasn't, if you mean whether I was following the legislative process, I wasn't at that point in time. I wasn't as involved in the legislative process as, for example, I am currently. I think from talking to the legislators, they understand what's been going on, at least the individuals I've been talking to, and the need to take a look at this and have some reforms in this area.
Yeah, it's interesting because now that we've been covering these cases across jurisdictions, right, we hear multiple DAs say something needs to change with this law, but at the end of the day, it did pass with bipartisan support. Why do you think that there wasn't more of a fight at the time when this was being passed to ensure that safeguards were put into place?
I'm really not sure why that occurred. Sometimes bills have unintended consequences and people don't necessarily realize what's going to happen when a bill passes, and then once they do, they are willing to go back and look at that. And I think maybe that's something that occurred here, but I'm very optimistic that we can work closely with legislators and others in the community to collaborate to get some solutions to these problems.
We've talked to sponsors of this bill, people who were advocating for it to be passed. Some of them would say, this is working exactly the way it's supposed to. In this case specifically, we want to see people who are mentally ill be civilly committed to get treatment, and this law opens the door for that to happen. What's your response to that?
I think that portion is working in this case, but it didn't work with this individual previously, and that's the problem. And this individual's had numerous competency evaluations over the course of the past couple decades, where sometimes we get people in for the first time, and then if that person is found incompetent and unlikely to be restored and gets released, that person still needs mental health treatment too. And so that's an ongoing issue. So here we do have the civil commitment in place to ensure this individual is not released into society, but we need that in place and more. That needs to be, in my view, the presumption that should happen.
And let's have some clarification on what's going to happen with this individual. We have covered cases in the past where someone was involuntarily civilly committed to a mental health treatment facility in the state because they were found incompetent and not restorable. It's my understanding that maybe this one is a little bit different. Reading through the court documents, it does say that this defendant actually agreed to go get treatment. So how does that impact the timeline at which this person could be held? Because in the other case we've covered, it was a 72-hour hold and then 3 months, 6 months, and then a max really of 12 before the state would probably have to release that individual. So how does this defendant agreeing to go change that?
So the civil commitment process is a civil process. It's not part of the criminal justice process. So I'm not 100% sure on the answer to that question. It's my understanding that it will be the 90-day review initially, and then 6 months reviews after that can continue the civil commitment. I don't know if there is any difference because he agreed to be civilly committed as opposed to being court-ordered in the first instance.
So can you guarantee that this person will remain in a mental health treatment facility indefinitely, or is there a chance that they do get released from there?
It's not up to me, so I can't make that type of guarantee. It's up to the treatment providers, it's up to the medical doctors, it's up to the people that will be treating this individual. They need to make that determination. They need to follow the state law that applies to them. That will be in their hands as to what happens to this individual.
We know in Colorado on a daily basis there's a lot of people waiting to get into a bed at these mental health facilities. Can you guarantee that there is space for this defendant to go to a facility right now?
So this defendant is currently in a mental health facility in the forensic ward, and it's my understanding they are just going to move over to the civil ward, so they will remain at that specific hospital.
I know going through these documents, what was interesting about this case is at one point this defendant was found competent by a doctor. People are going to see that and question, well, if they were found competent at one point, how are they now incompetent and not restorable and having these charges dismissed? Why not fight when that second opinion comes back as incompetent and not restorable as the prosecutor? Why not fight harder and say, hey, no, we had this competency finding before?
Yeah, there's a couple reasons. So first of all, this individual was seen 4 times by the state examiner. And on one occasion, the state examiner did say they were competent, but they were unlikely to remain competent through the course of the proceedings. So it's a 2-pronged test. They have to be currently competent and be able to remain competent throughout the proceedings of the case, because then if we begin prosecuting the case and they're found incompetent again, we're going to be right back where we started. So that one finding of competency, also that finding was unlikely to remain competent throughout the course of the proceedings. And then there was a second evaluator that looked at this individual and found this individual was incompetent to proceed and not likely to be restored. The other issue that we have in this case is there are time limits on how long we can hold an individual to try to restore them to competency. This individual was charged last year with attempted kidnapping as the highest charge. That's a Class 5 felony, and the time limit on the competency timeline for that is 1 year. So this individual's been incarcerated since April of 2024, so they have already passed their time frame, the 1 year time frame.
To make that concise for people who maybe don't have a legal understanding, your office isn't refuting that finding, even though they were found competent at one point and now incompetent and not restorable, because essentially there was no way that they were going to remain competent. Is that correct?
That's what the finding of the doctor was, that they were competent at that time, but they were not going to remain competent throughout the course of the proceeding. Again, we were going to be filing a written response to the defense's motion to dismiss, which is due on Monday, so we'll be filing that on Monday. And so we're still formulating what we're going to say in that motion right now, but we will be filing that motion or that response on Monday.
You read my mind. That was my next question. So can you give us any inclination as to what exactly your response might say?
Not at this point in time, but we are happy to share it once we file it.
When this news broke, the narrative out there was definitely that the DA is going to file a motion to dismiss this case. The defense is the one that's filed the motion to dismiss this case. And like you said, ultimately it's up to a judge. So I guess was the initial plan ever for your office to be the one to file for a dismissal?
You know, I don't know. I wasn't at that initial hearing, the one earlier this month, so I'm not sure exactly what transpired there. But when this case came on my radar, I said, you know, we were going to wait for the defense to file the motion to dismiss, and then we were going to review all the evidence available and file our response to determine what our response is going to be at that point in time.
Can you clarify for people that ultimately this is the judge's decision?
100% the judge's decision. So the defense has filed the motion, we will file our response. The judge needs to make the findings about competency, and then we'll make the determination of whether or not to dismiss the case.
I want to go back a little bit. I can hear people now saying, you mentioned at the hearing earlier this month you weren't present and didn't necessarily know exactly what transpired. There are people who are going to say, well, this is your office, you should know what happened in that hearing. What is your response to that?
We prosecute thousands of cases a year. I have over 70 attorneys working for me, so I am not at every single hearing. It wouldn't be possible physically for me to be at every single hearing. But as soon as this case came on my radar, I'm closely monitoring it. Again, I'm working on proactive measures to address the issues that I'm seeing in this case, and I am personally working on our response that we'll be filing on Monday.
Is this the first case on your radar since you took office 6 months ago that you know of dealing with this competency issue?
Yes, I think it is, as far as I know.
What was your reaction when you started piecing things together of going, our hands are pretty much tied here?
You know, it's frustrating. It's frustrating as a prosecutor. It's frustrating as someone who lives in this community, that has family who lives in this community, that our hands are tied. And this is something I've dealt with as a prosecutor in other jurisdictions, even before the law changed, that, you know, we have an individual who commits a crime, who's obviously mentally ill, and they end up getting released because they're not competent and they can't be restored. It raises grave community safety issues, and even before this case was on my radar, I was looking for legislative fixes to it, and so I'm very focused on continuing those conversations.
Are you hearing from other DAs who are dealing with this sort of thing and what they're feeling and how they're reacting?
I haven't spoken to any DAs specifically about this specific issue at this point in time.
I want to move on a little bit, and we're only going to briefly touch on this probably, but obviously there's a council member in your jurisdiction who is calling for you to be recalled. This isn't really necessarily what sparked it, but this has definitely become part of the conversation. In a statement, you said there's been a lot of misinformation. What misinformation do you feel is out there?
The councilwoman indicated that this case had already been dismissed. It hadn't. She indicated that we had moved to dismiss the case. We hadn't. She's made some statements that she thinks we are not filing specific charges, that we are not giving appropriate sentences. Our office has asked her numerous times to identify those cases that she's speaking about so that we can take a look at them, and she has said that she has just not responded. That's the misinformation that is out there. Also, I think the implication was that we had some sort of discretion as to whether or not the charges in a specific case would proceed. Again, it's ultimately up to the court, but the statute is mandatory in its language.
She's also brought up another case, a plea deal that was recently done regarding a teenager who was given a plea deal after a car accident that killed somebody. What would you say to your constituents, the people in your jurisdiction who don't feel like justice is being done for these victims?
So what I would say is that I was elected by the people of Arapahoe County to do this job, and I'm doing this job as professionally and as appropriately, and I'm standing up for victims in our county. That one particular case, we are very limited in what we can say about that case because that individual was a juvenile, and that individual has since been deported. I am working hard for the people of Arapahoe County. I am standing up for victims in this community, and I'm getting justice on their behalf.
What do you think and feel when you do hear that there are people we're talking to who say, we want to see our DA fight harder?
I listen to that. I'm an elected official, and I will take that into account moving forward.
Does it frustrate you about this recall at all? Do you feel any type of way about it, or what goes through your mind when you think about it?
It's very difficult to recall an individual under state law. She's going to need to get over 75,000 signatures. And so if that's how she wants to spend her time and energy, she can go ahead and do that. But I'm just going to continue doing the work on behalf of the people who elected me and continue to move forward with that work in the same way that I would before, and continue to stand up for victims and fight for justice for the people in Arapahoe County.
Is it interesting to you when you see other elected officials, DAs, council members, publicly scrutinizing your office on the internet?
They have the right to take a look at what we're doing and make their own comments, and I don't have any issue with that.
When it comes to this law, is there anything else that you want to mention, anything else you want to talk about I haven't asked about?
I think we covered all the points that are important.
Is there anything else with this Galligan case that you want to cover, clarify for people?
Yeah, I think it's important to note that under the civil commitment statute, these 6-month review continue indefinitely until a treating physician determines that this individual is appropriate to be released back in the public. So I think there was some misinformation out there that was capped at a year. That's not the case. They will continue to be reviewed every 6 months until they are determined to no longer be a danger to themselves or to others in the community.
Basically, they are reviewed every 6 months, and then if a doctor finds that this individual is competent and can function in society, then they are allowed to be released.
That's my understanding. So it would be up to the medical judgment of the treating physician.
Do you have concerns that even if someone goes through this treatment and they are released back into the community and found competent without that sort of medical guidance and without being in a facility like that, they will be released back into the community, back into your jurisdiction, and then commit crimes again?
That's always a concern. We can't predict what's going to happen. It's my understanding in most cases, once they get released from the secure hospital, they would go into some sort of community-based treatment. So that could be through a community-based, either I think inpatient is also available, is my understanding, as well as outpatient once that release would occur. Ideally, they would continue to get treatments once they are released from that secure facility.
One more thing about the law. A criticism we've heard is that it was passed with no funding. No new mechanisms to ensure that there's more space at these mental health facilities. Do you think that was a problem?
100%. I mean, we need to be able to fund these beds. We need more resources to treat mental health. I mean, we know that some individuals who commit crimes have mental health problems. And some of those individuals, if we're able to treat the mental health problem, they won't go forward and commit another crime. And so we need to have resources there. It will prevent crime ultimately, but it also will promote community safety. And we definitely need more resources. We hear many stories about long wait times, and we need to be sure that we're getting the resources that we need to get individuals treatment that they need.
And are you concerned knowing that this is likely not going to be the last case that your office deals with when it comes to this competency issue?
Yes, and that's why I'm out there advocating for legislative change so that we have more tools in the criminal justice system to deal with individuals who have mental health problems and who are committing crimes. I'm not sure why this case in particular has had the response that it has. I think in part it's because of the misinformation that was initially disseminated with the case, and then we do have the video footage, which is disturbing, obviously. It's disturbing factually, to hear about someone chasing children on a playground. That's very disturbing. And so, I've been talking, our office has been talking to the parents of the victims in these cases about, what we can do to ensure that nothing like this ever happens again. But, unfortunately, I think a lot of the misinformation that initially came out fueled the fire as to why this garnered national attention. But it's a very concerning case. As a member of the community, I'm very concerned about it, and that's why I'm doing everything I can to make sure nothing like this ever happens again.
Obviously, earlier this week, right here in Arapahoe County, there was a rally, a group of people out here advocating for change, and many of them, they chose the Arapahoe County Judicial Center because they're frustrated with your office. What is your response to that frustration?
I would say I share that frustration, but I don't think that frustration is appropriately addressed at my office. It's at the system. It's at the statutes that we have. And I call on everybody to collaborate. Let's work together. Let's get community members together. Let's get elected officials together. Let's address these issues. Let's change the law. Let's make sure nothing like this ever happens again. And we can do that much more effectively if we all come together and we work together and collaborate for solutions that actually make a change.